Yesterday, we focused on a new push to raise the age of legal responsibility in New York and the effort to prevent teenage suspects from being tried and imprisoned as adults. In that effort, it brought together a number of legal minds and other people to a meeting in Rye, New York. New York and North Carolina currently, believe it or not, the only states in the country that treat all 16 and 17-year-old suspects as adults without exception, a process that disproportionately impacts young people of color. And it can also have huge impacts over the course of somebody's life, not just in that 2-year window. Now, here are some facts from the public awareness campaign. As we stated, New York and North Carolina, the only two places in the country that prosecute kids 16 and 17-year-olds, even for minor offenses. Teens in adult facilities are 36 times more likely to commit suicide when compared to teens in juvenile facilities. Over 70% of children and youth arrested, there are people either black or Latino, and 80% of those sentenced to prison are black or Latino, as the chief judge of New York, Jonathan Lippman, told our own Andrew Whitman. These teens, he says, are victims of the process.
Overwhelmingly, these are nonviolent crimes, not something that society should seek retribution and punishment about. These kids need help, and by not giving them help and instead focusing on punitive measures, we victimize them. We make them, or they become adult criminals instead of becoming kids who did something that maybe wasn't so smart. Get them whatever help they need, get them on the right path, emphasize services, not punishment.
Now, it's worth noting that even with a change, some teens, like those accused of murder, they'd still be treated as adults, but only North Carolina and again New York treat every teen that way. Now, we're going to bring in our panel on this. Jimmy Koussouras, criminal defense attorney in Manhattan, lecturing at New York Law School and a visiting professor at the University of Birmingham in England. William Aronwald, criminal defense attorney, former federal prosecutor and former prosecutor at Aronwald and Pickett. Mayo Bartlett, attorney and former chief of the Bias Crimes Unit at the Westchester County DA's office. Mark Furnish, professor of Brooklyn Law, and he's argued before the U.S. Supreme Court. And May, I'll start with you because you helped really put this event together. I think a lot of people are surprised because they think of New York as this blue state. But, for example, arrests of marijuana, New York City more than any other place, period, does it. And now even sentencing minors. People are surprised to find out that New York's right at the top of the list.
Absolutely. New York is actually one of the least liberal states, if you really think about it, one of the least progressive states. And it goes beyond simply how we treat children, but even if you were to have a felony conviction in Mississippi, you have a chance of getting that expunged. That's not the case in New York as an adult. And one of the things that we're finding is that when you start to criminalize children at an early age, it just sets them on a path that they follow for the rest of their lives. And it just begs the question, if we deem that children cannot drink alcohol until you reach 21 years old because we don't trust your judgment, how in the world then can we trust your judgment and blame you for your inability to make just decisions?
I think now somebody at home is saying, oh, okay, wait a minute here. A kid goes in and robs a liquor store and shoots up everybody. Now we're looking to treat him with a slap on the wrist. We're not talking about the heavy felony stuff. We're talking about some small stuff. Give an example of what we're talking about where they're automatically treated as adults if they do it at 16 and 17.
Well, you're talking, basically they're automatically treated as adults in the criminal justice system for something as small as a petty larceny. Now, you can seek youthful offender status, but again, the initial crime itself is treated as an adult. And also, even things...
Translate that to the regular person. What does that mean?
That means somebody steals, Bill's mug, okay, and we get the mug back. That
Good
person now has
justification for that, because everyone wants a mug that touched his lips.
But that child will have on their record, potentially, if they're not treated as a youthful offender, a crime for the rest of their life. But beyond that, let's assume they go into a facility, a criminal facility, a jail. They'll be in the same jail possibly that adults will be in. In fact, Rikers Island, I believe, is the only jail that segregates kids under 18. And that segregated population is one of the most violent prisons in the state, more than some of the supermax.
And people have seen that from the headlines. Guys, tell everybody why we should care. I mean, you guys have been, you've been on the prosecution side, been on the defense side. Why should people at home care and say, these kids are trouble anyway?
How can we not care? These are our children. They're going to grow up to be the adults that our children grow up with, and so on. Young children are malleable, their brains are malleable, they are susceptible to interventions, they're susceptible to programs, they're susceptible to fixing before you continue to break them. Why do we care? This is for the same reason we care about our children when they do something wrong. We want to help them not do it again, as opposed to put them in an environment where we're encouraging them to do it again by putting them with people that are going to tell them to do it again and they're going to associate with. So of course we should care.
I have a little bit of a different take on this. First off, even though New York and North Carolina are the only states that anybody under the age of at 16 are considered adults, the fact is in almost all other states, a child at the age of 14 can be prosecuted as an adult.
But they're not automatically prosecuted. It's judicial discretion.
No,
right?
but again, Mayo mentioned something in passing, youthful offender. We need to understand what youthful offender means. In New York State, even though you are treated as, quote unquote, an adult for prosecution purposes, if you are charged with a misdemeanor, stealing this mug, that's a misdemeanor. So if that case is disposed of either by a plea of guilty or a conviction, because it is a misdemeanor, the child basically does not have a criminal conviction. He has a youthful offender adjudication. His record is sealed. If he's ever asked on any application, have you been convicted of a crime, the answer is no. If he's accused of grand larceny and is treated as a felony, the judge who presides over the case, even if a jury finds that person guilty or if the person pleads guilty, that judge still has the discretion to substitute the conviction for a youthful offender adjudication. So New York State has a mechanism in place where basically someone at the age of 16, between 16 and 19, even though charged as an adult, can come out at the other end of the tunnel, not with a criminal conviction, but as a non-criminal youthful offender adjudication.
Bill, the difference there is that you're now relying on a judge's discretion as opposed to saying this is automatic.
Not
so
in
now,
misdemeanor cases,
with
it's
respect
mandatory.
to felonies, and again, if you go back to felonies, if you damage property over $250, it's a felony. If you steal something worth more than $1,000, it's a felony. So you can have felonies that probably are outdated because they're not keeping up with the times in terms of value of things. And depending on what community you're in, you may be more likely to get that youthful offender treatment than in another community.
It's also the time in the tunnel. Let's remember, they get arrested, they're arrested as adults. If they can't make bail, they're sitting in a jail, again, in a negative environment.
We learned how the clock works in the 6-month clock.
That's right.
And the funny math there.
You might come out okay.
Isn't there also a math thing? I know we're heavy, I want to get to the next one, but there's also a math issue which says, is this the best way to spend dollars, whether it be incarceration or whatever else? I mean, the rate of reoffending for kids to go into the programs, and believe me, this isn't bleeding heart, but just practicality, how much it costs to house these kids here, even if they're just awaiting trial, versus putting them in a diversion program. I'm not saying the really bad ones. I'm talking somebody who swipes a laptop that's worth $1,000 or whatever, or steals a car or something else. Is the best place to put them behind bars or to try to treat them just from a practicality standpoint? Forget the, whether I need a suture for my heart here because I feel for the kid. Isn't the math part of this too?
From every standpoint, the math makes better sense to put these kids into diversion. The drug courts have made it so clear. The recidivism rate is so much lower. You can fix many of these kids.
I want to get to so much in this half hour, but Judge Lippman, who appeared and spoke, Chief Justice here, we're going to hopefully bring him on the program, and he's going to talk about this. He's pretty vocal about this subject. But when we come back, Mark's pointed this one out. There's many small business owners who say they're just trying to make an honest living. They're being treated like criminals, not by the cops or by the IRS, but we're going to talk about why the IRS and what the rule change is, what it means if you're a small business owner out there. I don't think everybody at home has a full appreciation of what just changed. Stay with us.